Lots of changes are being made to family-friendly leave because of the Employment Rights Act 2025. This includes in relation to paternity leave, when you can take it and how much time you need to have been employed for before you can take it. Annual parental leave is changing, and also bereavement leave, including miscarriage leave as well. That's been introduced by the Act. The Employment Rights Act 2025 introduces significant improvements to family-friendly employment rights, removing barriers to leave and extending bereavement protections. The key changes include, firstly, the Act removes the qualifying period of employment previously required for parental leave. That's the 4-week period of unpaid leave available to parents annually, up to a maximum of 18 weeks per child, meaning employees can access this right from day one of employment. Secondly, the qualifying period for paternity leave, both following birth and adoption, is removed, allowing employees to take paternity leave from the start of their employment. Thirdly, employees are no longer prevented from taking paternity leave if they've already taken shared parental leave, providing greater flexibility for new parents to structure their leave. Next, the Act significantly expands parental bereavement leave into broader bereavement leave. This extends eligibility beyond bereaved parents to anyone who satisfied specified conditions, which will be set out in regulations, as to their relationship with the person who's died. Critically, the leave now also covers employees who've suffered a miscarriage in the first 24 weeks of pregnancy. Finally, the Secretary of State has been given powers to make regulations about dismissal, other than by reason of redundancy, during or after a protected period of family leave. These regulations may cover what notices need to be given to the individual concerned, the evidence that may need to be produced in relation to the reasons for dismissal, and the procedures that the employer may need to follow, as well as what will happen if the employer fails to comply with these obligations. This extends pregnancy protections significantly beyond the existing redundancy-specific provisions. Given the removal of the cap on unfair dismissal compensation, employers should be careful to follow whatever rules are put in place by the government in this regard. For more details, please head to our website, mishcon.com, and look for the Employment Rights Act Hub. There you'll see more information regarding the content of the Act, when different parts of the Act are coming into force, and what still needs to be decided. You'll also be able to download guides as to what employers should be doing to prepare for the changes, and what training we have available for your managers and HR teams.